Welcome back to Law and Order. I'm your host, Mehak Khattar, and today we are tackling one of the most sensitive areas of employment, terminations. Whether you're a foreign worker worried about your status, an employer unsure of your obligations, or an HR professional managing risk, terminations can trigger a cascade of legal and compliance steps. And to break down the HR, US immigration, and Canadian immigration sides of this, we have Leona Wilson of Armillary Business Group.
Hello.
We have David Nachman from VisaServe NPZ Law Group.
Greetings, everyone from the States.
And Gagan Mundra of Visaserve Canada.
Hello from Ontario.
Let's jump right in. Leona, starting with you, employees on work permits often fear that they're more vulnerable during layoffs. Is someone more likely to be terminated because they're on a work permit?
That's a great question. Not actually because of the work permit, but it might work out that way. When we're looking at doing downsizing within an organization, we use a few different filters. In some cases, it may affect a specific business unit. In that case, it might catch somebody who is in on a work permit. It could be around the most recent hires will be the people to be released first. That could be an option as well. We don't use the filter of are they on a work permit, because that in itself would be discriminatory. Generally, the decisions for how we're going to do the terminations are really going to be dependent on the line of business. Are there any kind of collective agreements in place per se? And a number of other budgetary factors. I've been in environments where basically each department head has been told that they need to do a downsizing per se and to put forward a name of an individual. It could work like that. It could be on seniority. There are multiple factors, but the work permit in and of itself is not the determining factor. Back to you.
That is quite reassuring to know, and I know I'm speaking on behalf of our audience, but I'm sure a lot of people are going to find that reassuring. Let's shift to the immigration side in the US. David, if an H-1B employee is terminated, is there a grace period before they must leave the US or switch employers?
So thanks, Mahek, for that question. It's actually one that we're getting sort of on a regular basis. And as many folks are aware, the economy here in the US is taking some interesting twists and turns, especially under this administration. And so for H-1Bs, the answer is yes, there is a grace period. It's actually regulatory. There's a 60-day grace period. The problem with that 60-day grace period, especially in an economy such as this, is how do you find something new? So it's really difficult in 60 days to try to find something new. So what we do is we try to offer alternatives to our clients. And again, we're not coming at it right now, or at least I'm not presenting it from the employer perspective. I'm presenting it more from the employee perspective. And that is that, individuals find themselves in a situation where they may not necessarily be able to find something in 60 days. They usually work with, depending upon the size of the organization might provide some outplacement support. That might be a possibility, but more often than not, what we do is we offer up to our clients, our corporate clients, and also the individuals, the opportunity to change their status to maybe a visitor, with the expectation that that gives them enough breathing room where they can then go back later on. That breathing room is usually about 6 months, and sometimes, depending upon the economy or the situation, it might have to be even up to a year. So we're pretty successful in getting that. And then what we do is we can go back to the H-1B, because they can always go back to that H-1B. So yes, there is a grace period. It's a good thing. I think it works out well for the employers, and it works out well, for the employees. Over to you, Mehek.
That's actually really good to know, because that small window of time can make a whole difference for people who are trying to stabilize their situation. Now let's bring in the Canadian side of termination. Gagan, when a foreign worker in Canada loses their job, how long can they legally stay in the country after the termination?
whether you are on a work permit or on a study permit holder. So that defines your status. And temporary resident visa is the one that CBS provided to you. It's stamped on your passport when you entered Canada. Now, when you are inside Canada, you unfortunately, if you lose your job, then you're still able to continue staying in Canada as a valid resident visa. So as a visa holder, you could still continue staying in Canada and not run out of status. You will be under implied status. Now, it's also very interesting that I'm going to point it out how our regulations are laid out. Under the regulation section 209 of Immigration and Refugee Protection Regulations, a work permit becomes invalid when it expires or when a removal order that is made against the work permit holder becomes enforceable. So what that literally means is that even if you've lost your job, you can continue staying in Canada under an implied status. Look for other options that you would have. You cannot be breaching your work permit options under which you were admitted in Canada. So you cannot be working, even though your work permit will be valid, but you cannot start working for other employers unless they apply for your work permit, do their LMIAs, etc. So be very careful what your underlying status is if you have lost your job.
That's extremely critical, especially because many people assume that they have unlimited time. But immigration rules tend to move quite quickly. Back to HR, because HR plays a major role in the entire termination process. Leona, after a termination, what government reporting does HR need to complete, especially for employees on work permits?
Thank you for the question. I'm actually going to defer to Gagan to really go through that part of your question in terms of what has to be reported specifically because of the work permit. But there are other government agencies and reporting requirements that we do have that will impact an individual who is on a work permit. So as an example, through Service Canada, there will be a notification, and that will come through the record of employment. So we will issue the individual a record of employment, and they may qualify for employment insurance benefits. So that's going to go through that record of employment piece. If the individual is under any kind of garnishment orders, then we will have to do some reporting there as well. So a garnishment order is really a court order, or it's going to come directly from the CRA, and it is for money that is owed. So the ones that we tend to see more often will come from Canada Revenue Agency for unpaid taxes. Within the province of Ontario, it's not uncommon to see orders that are coming through from the Family Responsibility Office, which is for any kind of spousal support or childcare. But if there's any other creditors that have successfully received court orders, then there's going to be a garnishment order that will come through as well. In Ontario, that's all determined by the Wages Act, how much can be garnished. But in a situation like that, where we have a garnishment in place, we are going to go back and disclose to wherever that is coming from that that individual is no longer with us, because we are continually responsible to remit until we tell them that there is no more income from which we can remit those garnishment orders. The third area where a reporting will come through, but this is indirect, is through Statistics Canada. As an employer, we might be selected to complete a monthly job vacancy and wage survey. And in that survey, we have to indicate whether we are hiring for a replacement position. So if we've released somebody, regardless of the work permit or if they are here otherwise, then we do have to report that we're actually looking for somebody. But again, that's going to be anonymized. It's not going to tie back to the individual directly the way a garnishment or a record of employment will. So thank you.
Now, before I move on to David with my next question, Gagan, can you explain a little bit more about how the legal side ties into this? Because like Leona mentioned, it seems as if in this case, especially when work permits of foreign workers are involved, it's important that HR and legal cooperate with each other to solve this.
That's an excellent question. And it's not just at the time of termination, it's even before. So I actually had a consultation last week where this employee is on a temporary, she's a foreign worker, she's from the US, and she also has a company in the US which is not registered. She's just doing some kind of product she's preparing from scratch. Now, her employer in Canada laid out, had an exhibition, and the employer allowed her to display the products of her company as well, although that company is not registered. Now, what happens to that income that she's generating from this kind of sale? Is that legal? No, because she's under a closed work permit to work with that particular employer, and she could be selling the products, but then it only comes down what is the relationship between that company in the US as a vendor with this Canadian employer. So it just becomes very tricky, not just at the time of termination, but even during your employment with the employer in Canada. What are the terms and conditions? Go back to your employment contract. That literally is your Bible, how you should be working on your terms, on the terms and conditions that have been laid out in that contract that you signed. And for whether it's a foreign national, it's a Canadian citizen, or a permanent resident, law remains the same for everyone. There are labor laws, common laws, everything that is available to each one of us who are into that situation and can avail it to their to seek a benefit out of it. Over to you, Meg. So it all depends on the employment contract, where you are, your provincial regulations, how they support your situation, and if you are really eligible for any kind of a benefit, etc.
That's extremely interesting and also very, very helpful. Speaking of legal obligation, David, let's expand this on the employer side. What obligations does a US employer have when terminating an H-1B non-immigrant? Are the obligations different from other immigrant visa holders?
Yeah, so great question, Mahek. And before I get into that, I just want to go back on what the ladies were speaking about, because as you're speaking about terminations, I'm thinking to myself how much of an impact that has, at least in the context in the US, on non-immigrant and immigrant visa processing. Because as we're talking about terminations, I'm reminded of the WARN Act here in the US. And I think, Leona, you were talking about something that's sort of comparable in Canada. I didn't realize that so many, it seems that employment is so highly regulated by these administrative agencies. It's really, I don't think it's as much here in the United States, but I'm reminded of the WARN Act, and I'm reminded about, what potential impact layoffs or terminations have on the non-immigrant and immigrant visa processing. Because, of course, if we have individuals who are either terminated or laid off, that could potentially impact on recruitment, whether or not recruitment should be done in that SOC, that in that occupational classification. So really interesting issues that you're bringing to the forefront, and how that segues into the US. But Mahek, just to get to your question, there are two, actually, Mahek, you made a really good point, and I just want to highlight that for anyone who's tuning in. And I know you're more of the moderator, but the point that you made is great. And that is, make sure when you're involved in terminations or layoffs or anything of that nature, make sure that you involve your employment counselor, which I think, Leona, it's your bailiwick, or labor and employment counsel legal, to make sure that you have all of your everything covered. It's so important, because that's where things could potentially explode. With regard to terminations of H-1Bs, as a matter of fact, it's kind of a very timely issue, because it just came out as a release yesterday from the government here in the United States, that in order to do a proper termination of an H-1B, employers need to withdraw the H-1B. And not only do we tell them to withdraw the H-1B, we also tell them to withdraw the LCA, but they don't have to do that, but withdraw the H-1B. So a formal withdrawal needs to be sent to the USCIS. You also have to make sure that the separation in the relationship is clear. So there has to be a clear separation. And you also have to offer return transportation. So how do you do that? The H-1B requires you statutorily to offer return transportation to the individual that they're going back. But do you do that through a severance agreement? Do you do that through a separate letter? How do you do that? It's really sort of an interesting thing because I'm monitoring how my colleagues on a listserv, how they do it. So it's, there's no specific way, there's no cookie cutter way to handle that. So everyone sort of has a different way of going about it. But that is sort of the appropriate way to withdraw an H-1B. And what is the problem if you don't? Well, if you don't, then the employer is responsible for an ongoing wage obligation. So an employee who is left where the employer hasn't done this can make a complaint to the U.S. Department of Labor, and potentially for all the time that has not been done, that appropriate separation has not taken place, then the employee is allowed to get wages. So that's the exposure, and it could be tremendous. Back to you, Mac.
That makes a lot of sense, and it actually clears it all up. Different categories, different responsibilities, and none of them are optional. Let's go back to the Canadian framework now. Gagan, what obligations do Canadian employers have when they terminate a foreign worker? Is it the same as terminating a Canadian citizen or a permanent resident, for example?
We covered most of it. Again, go back to your sacred document of the contractual agreement. What were the terms and conditions that you were signed? What is the employer obligations under the provincial and federal law? Is it a union or a non-unionized employer? So you have to go through all those terms, conditions. It would not be, again, a straight yes, no answer. These are multiple documents that we'll be relying on as lawyers. It would be your Employment Standards Act, your provincial law, common law. So those are the documents, those are the regulations that we'll be relying on and what the courts are leaning on. At the end, if you are in an unfortunate situation, of course, there is law to protect you, and make sure you avail those right on time, because there could be limitations as well. And reaching out to legal services would be hugely beneficial.
Absolutely. And that's a meaningful distinction to make between who you need to reach out to for help as well. And back to HR for a more practical question that affects the next steps that people take after termination. Leona, after a termination, will HR still provide a reference to help someone find a new job? Or is that dependent on circumstances?
Thank you for the question. I would like to just step back to something that David had mentioned, and that is around the requirement for return transportation. We do have that in Canada as well, in some cases, depending on how the work permits have come forward. So that is, again, to what Gagan had said as well, we have to go back to all of the source documents. So that is something we might have to take into consideration as well when we're looking at a termination, if that's the case. But to come back to your question around the reference, the companies generally will have their own policies for whether or not they will provide references or not. Many will not these days. However, they will confirm employment. So I would suggest best practice for an employee on a work permit who is being exited for whatever reason is to ask for a letter confirming employment, or maybe to ask for a reference letter that they could have. At least that way, if they have that on company letterhead from a company official, then they can use that. And then from there, a future employer could go back and could verify it. Many larger companies, though, are delegating all of the reference checking to third-party providers. And in that cases, there's no difference for what the assistance will be for the past employee. It really depends. So there's no distinction for we will treat somebody on a work permit differently than we will treat anybody else who is in our employment area.
But then what happens, Leona, in case the employee doesn't leave on good terms? Then is that still an employer obligation?
We do not have to provide a reference. However, we can find ourselves in trouble if there's a common law issue in not supporting the employee to find alternate employment. The way we get around that is we will provide a letter confirming employment, and we will always try and find something nice to say. In that we might say that, the team members liked working with them, management didn't, but maybe the team members did. We'll find some way to put it so that we can say something positive that speaks to the work that was done, and leave it at that. Generally, people will read through the lines. This is really something that is the basis of what the companies themselves will practice. I know myself, when I was working corporately, when I'm working with my clients, I always advise, let's find something to say. And it's better for us if we can just give to the individual a letter at the time that they're leaving us. And at least that way they have something that they can take with them. And then hopefully we don't have to engage with that individual again. They have what they need and they can move on. Certainly there are many employers who are reluctant to provide negative references because it can blow up if it's not something that could be substantiated. However, it's also very clear that if you as the employer are providing information based on the knowledge that you have, you are okay. But this is where people tend to be a little bit reluctant to go ahead and provide any kind of references at all. And this is why I suggest asking for a confirmation of employment, your name, the position, the period of time that you worked is good. For myself, for a confirmation of employment, I will always omit the salary, because I find it is easier for the employee then to go ahead and negotiate their own salary rather than an individual saying, well, that's what you used to make, so we'll just base it on that. We also have pay transparency legislation that's coming into play where we're not supposed to be asking questions like that in certain jurisdictions. So leaving the salary off, I think, is just better for the employee.
It becomes
Well,
very
Leona,
tricky for us when we have to file any express entry applications, and at that time we need that proof of employment, and that would be one of the reference letters, etc. And yes, the alternates that we think of is affidavits from the supervisors, managers, and of course all their T4s and pay slips that could help to make that immigration application stronger. But it's always good to have a reference letter. I'm sorry, David, over to you.
No. So Gagan, as you guys are discussing this on the Canadian side, I'm thinking if I'm an employer, the next employer in line, and I receive a letter like that, it's almost like what I'm going to do is look at that letter and say, is this a template that, let's say, a labor and employment advisor or consultant like Leona has told someone to prepare on the other side? Or is this something that I can really entrust as being genuine as opposed to, right? So it's kind of interesting because you look at it and you'll say, okay, well, this is, that will go into the determination as to whether or not someone is going to be viewed really well at the next step in the process or not. So it's really interesting. Yeah, I mean, here in the United States, we won't, generally speaking, we don't even issue letters or templates of that nature whatsoever. And I was just, as you were discussing it, Leona, I'm wondering whether it's being done as like consideration or a quid pro quo so that the individual doesn't come back and potentially, because here what we'll do is we'll have a severance agreement signed where they'll waive all their rights under various provisions of the law to come back against the employer. And I'm just wondering whether giving a letter like that is like a quid pro quo. I'm sorry, back to you.
Sorry, I want to cut in on that point. We will often offer to provide a letter as part of the settlement in order to secure the release. So this is part of the consideration. We're saying goodbye to you. We'd like you to take what we are offering to you, and this is part of it, so that this will help you. And usually it's worded to be mutually agreeable. In my experience, I've not had anybody come back and ask me to rewrite them. And I think part of that is because I'm always trying to say something complimentary. The reality of it all, when we are truly honest about it, an individual not being a good fit for our organization anymore doesn't necessarily mean that they're not a good fit for any organization. And if there has been some wrongdoing, really serious wrongdoing, we're not going to be providing any letter. We might not even have to provide a settlement. It might be based on the evidence in front of us and the advice that we're getting from our lawyers. Goodbye, we're done. In a very serious situation, that's not the kind of person who's looking for a reference letter from us. So it's very contextual in that regard.
And another part which I'm going to take from Leona's discussion is about the pay commission, how in Canada, we don't want to provide all that information about the salaries, etc. And how in US it's shifting towards having all the salaries to be displayed wherever an employer is looking for a job position or hiring, and in their advertisements, it has to be put out there. So I just keep, it's so mind-boggling how US and Canada do things so differently, where we don't want to share any information and keep it covered, and where in US they say, okay, you're posting this job and it has to come with the bracket of lowest to highest.
Yeah, that's a remnant, I think, of the feudalistic thought process that's carried over from Europe, but that's neither here nor there. Over to you, Mahak.
Those were very stimulating, all very, very interesting points. And the one thing that is my biggest takeaway from this is that regardless of whether you're working on the Canadian side or on the US side, empathetic leadership, especially whether that's professionalism in terms of the employee following the rules, but also the employer, is really, really important. Now, I'm going to move back to David. I know we've discussed a lot of H-1Bs with you in just this segment, but we want to move and learn a little bit more about what happens when employees are terminated in other non-immigrant visa categories. Especially since in the US right now, they're moving away from H-1Bs, and there'll be more people interested in other non-immigrant visa categories. This becomes really important.
Exactly, Mahak. Actually, you stole my thunder a little bit there, and that is that we are moving away from H-1Bs, but we shouldn't be moving away from H-1Bs because, we've now established that this $100,000 fee that the government has announced really applies in very, very limited circumstances. So hopefully it will not change, what's been done in the past with regard to the H-1Bs, because it really just applies to people who are outside the United States for new H-1Bs that are being done in the next lottery, not for folks who already have H-1Bs. So that's sort of the general rule. But with regard to, and this is my standard answer to my clients or people or prospective clients who ask me this question, is and I always get this question from employers that are thinking about doing sponsorship for someone, and that is, what are my obligations? Of course, we already talked a little bit about that, but I always explain to them that ordinary labor and employment laws apply. So it's really important for us as immigration counsel, because that's what we're specifically doing, to work very closely hand in hand with employment and labor counsel, and to help them. They help us understand what those regular employment laws are, and we help them understand, what the immigration results are, or the immigration, processes, and then we work together to get the best possible result for the clients. So the answer there is that, for other types of visas, with the exception, I think, of the R1, which is a religious worker visa, where there is an affirmative obligation to notify the government if there's a change within a 2-week period. Other than that, and that's because there's just a really high fraud rate for those types of visas. But and they're too scared to get rid of it in the out of the law, because you're not going to make any friends if you get rid of religious worker visas in the United States, right? So they're going to let it go, even though it's a very high fraud rate. So everyone's afraid of getting hit by lightning after they get rid of the religious worker visas, so they just let it go. But with the exception of the religious worker visa, where you have that affirmative notification, and the H-1Bs, which I already discussed, ordinary labor and employment laws apply. So, the answer there for anyone who might be tuning into this webinar is work closely with employment and labor counsel or your labor and employment consultants like Leona to make sure that you have everything ticked and tied out. Back to you, Mehak.
That was extremely helpful, especially since wrapping your head around so many different categories can sometimes become difficult. That is a very important information to remember. And Gagan, let's close with something that impacts many, many families here in Canada and also in the US. But just in the context of Canada, if a principal applicant loses their job, can their spouse who's on a salient open work permit continue working, or does their status sort of change automatically?
That's such a good question, and it's so timely because so many changes have happened with spousal work permits. There were abuses of this kind of a work permit, and hence lot of strictness on the regulations on this aspect. And C41, C42 are the two spousal work permits. Either you are a dependent of a work permit holder or a study permit holder that defines your classification. Now, if the principal applicant loses their job, then the study permit, the spouse continues to work with that open work permit. It continues to remain valid. It's very interesting that I would want to point it out that how young, how evolving our immigration is. So up to 2021, even though it was, I cannot find a logic out of it. So even though the spouse had an open work permit as a dependent, as a derivative of the principal applicant, and then if the principal applicant lost his job, then they could become again a derivative of the spousal open work permit. And it was in 2021 that we changed that regulations where they say, okay, this is principal applicant who is the one who first applied for a study permit or a work permit. Based on that, the spouse applied for a open work permit. Hence, if the principal applicant loses the job, they cannot again become a dependent of the same spouse who was acquiring their status on the principal applicant. That really bothers me. How did it left loose for such a long time? And it was only in 2021 when we fixed it. But yes, the short answer, they can continue working and till the time their work permit is valid. But after that, they do have to maintain their status, which would be applying for a visitor record, or if they have already, the principal applicant already arranged another position, another work permit, then become a derivative of that.
That is very, very interesting to know the fact that till 2021, anybody coming in could have become, even the salient open work permit applicant
Correct.
could have become the principal applicant. Wow,
Mhm.
that's very interesting to know.
Yeah.
And any of you have any closing remarks or anything you would like to add to today's discussion?
I just want to again highlight the importance for any of the listeners to this webinar who, if you're considering terminations, layoffs, or anything of that nature where it potentially impacts either one or many individuals in your workforce, it's always a great idea, again, to seek out the expertise of individuals who, at least on the immigration side, handle work permits and understand the nuances, both on the Canadian side and the US side, as well as someone who is extremely skilled in the nuances of labor and employment, such as Leona, who handles this stuff on a daily basis and is familiar with those nuances. And combining those nuances will make a termination, which could be an extremely painful type of experience a lot easier, and it'll smooth out the bumps in the road for you.
I so much agree because we are dealing, when it comes to that kind of a situation, we are dealing with termination law, which is under employment law and immigration. So you have to be maintaining your status as well while you are trying to figure out what the next steps are and how you're going to secure the next job. So be very careful if you're into that situation and handle it with legal support.
Definitely a team approach.
Yes, yes.
Well, on that note, thank you so much, Leona, David, and Gagan, for joining us for another episode. Like all three of you said, terminations are hard, but the confusion that follows doesn't have to be. Understanding timelines, employer duties, and immigration implications can really help people navigate the transition a lot more confidently. This has been Law and Order, where HR and immigration meet clarity, compliance, and strategy. And please feel free to check out our other episodes on our channel. Click the bell icon so you're updated every time we post another episode. And make sure that you subscribe and give us a like and leave any questions that you may have in the comments. And maybe our experts will answer it in the next episode. Thank you so much. This is Mehak Khattar, and see you next time.
Happy holidays, everyone.